Menaka Gandhi was issued a passport in 1976. The following year, in 1977 though, she received a letter from the Regional Passport Officer Delhi informing her that it was decided by the Government of India to impound her passport in public interest. Yay, we are finally doing the Menaka Gandhi case. Hello and welcome. My name is Priya Mirza, and this podcast is The Longest Constitution, where we are looking at a reinterpretation of Article 21 in the Menaka Gandhi case, as well as a closer look at 1971. The case filed by Raj Narain challenging Indira Gandhi's election, as well as the passage of MISA, the Maintenance of Internal Security Act, which became the government's tool of repression during the emergency. But first, the year is 1977 and Menaka Gandhi's passport was impounded. And this was in fact following procedure. So Section 10, Part 3, Part C of the Passports Act 1967 stated that if the passport authority deemed it necessary in the interests of the sovereignty and integrity of India, the security of India, friendly relations of India with any foreign country, or in the interests of the general public, a passport could in fact be impounded. Nonetheless, Menaka Gandhi petitioned the court that this procedure prescribed by the Act was arbitrary and unreasonable. And this case is a landmark case in the history of procedural due process. So, in previous episodes, A.K. Gopalan 1950, which took place before this case, and then the Sunil Batra case 1978, which was a year after Menaka Gandhi's passport case, this phrase has cropped up: due process. But what does that really mean? And for some reason, I'm really thrilled with myself that we are doing this in the last episode of this year so that one can thoughtfully chew over this weighty matter as we bring the year in. So, what is due process? What makes a law valid is due process, which means that if a law is validly enacted and follows the procedures spelled out in the Constitution and follows parliamentary procedures, it would mean that the law is valid. But, does that give the legislature unquestionable authority on passing laws which are substantively unreasonable? So, this is a historic moment because I am going to give you a hypothetical example. Yeah, it's never ever happened before, and you can go and listen to the 71 episodes of The Longest Constitution just to cross check. Okay, so hypothetically, Parliament passes a law, and let's call it the Criminal Amendment Act 2023, according to which it is a crime to wake up at 5 in the morning, a crime which I am so guilty of. And a section of the Act amends the Criminal Procedure Code and provides that anyone tried for the offense of waking up at 5 in the morning will be denied the right to be represented in court by legal counsel. So, part 1 is substantive law, and that's regulating human behavior and defining a crime. And the second bit is procedural, the procedures and methods relating to that, such as the trial, being represented, etc. So, what made the Menaka Gandhi case a landmark case was the judgment about the procedure specified in the Passport Act 1967, which was a valid law, but its procedure was being challenged as being violative of natural justice. So, let's mull over that for a bit. So, I did mention that this is the last episode of this year because I have some very pressing work to do, like stare out of the window. It's imperative to stare out of the window. And at the end of the episode, I will be telling you what you can look forward to listening to in 2023. But for now, let's return to 1971. In the 1971 elections, Indira Gandhi contested from Raebareli. And interestingly, there were rumors that she would contest from Gurgaon, but in a press conference, she dismissed it. And Indira Gandhi began a campaign. Candidates also contesting that seat were Raj Narain and Swami Advaitanand. So let's reflect upon campaigning itself. And campaigning laws and funding is regulated in India by the Representation of People Act 1951, which recognizes that elections cost money. In India, to fund a campaign, private contributions are permitted, but spending by political candidates is capped. And we have looked at campaign finance laws previously, and that would be in the episode titled The Ambanis and Defamation Case and Electoral Bonds. So do listen to those two as well to get a fuller picture of what was happening with Indira Gandhi. Our last story of the day is the gloomy account also of 1971 in Parliament. When the draft bill of what became the Maintenance of Internal Security Act 1971 was presented, this is what Pilu Modi of the Swatantra Party said. What does this bill do? It snuffs out habeas corpus in the middle of the 20th century after 25 years of independence. Like other preventive detention laws, MISA authorized pre-trial detentions based on the satisfaction of the central or state government and allowed the state to assume vast discretionary powers. The opposition to MISA spanned the political spectrum from the left to the right. Vajpayee, L.K. Advani, Somnath Chatterjee registered their protest against such an act, but it was passed nonetheless, pointing to the dangers of a majoritarian government. Meanwhile, what happened to Indira Gandhi in Raebareli in 1971? Raj Narain was routed by Indira Gandhi by more than 1 lakh votes. Narayan, though, was convinced that Indira Gandhi had used unfair means to win these elections. And the Representation of People's Act 1951 specifies that the result of an election can only be challenged by an election petition brought before the High Court within 45 days of the announcement of the result. And on the 45th day following the election result, Raj Narain filed a petition in the Allahabad High Court challenging Indira Gandhi's election. And what happened to Menaka Gandhi? Menaka was not in fact given her passport, but the judgment was a fresh interpretation of Article 21. In Maneka Gandhi versus Union of India 1977, the 7-judge bench stated that the Passport Act fell short of the principles of natural justice, that before or after taking away a person's right to go abroad, a passport officer had to give the person a hearing. The right to be heard before having one's passport impounded was read into the Passports Act. So in comparison, where the Gopalan court had held that procedural due process was not included in Article 21, the court in the Menaka Gandhi case said that it was. So to throw a bit of Latin in, that's audi alterum partem, which means to hear the other side. Bhanu, thank you for telling me that. So as we wrap things up, the petition filed by Raj Narain was just the start. Considered at first to be frivolous and treated most lightly, over the course of the next 4 years, it indicted the serving Prime Minister and became the immediate trigger for declaring emergency in 1975. The second, MISA was a prescient weapon in the hands of a majoritarian government. And as a matter of fact, barring 2 short periods between 1970 and 71 and 78 and 80, India has always had at least one preventive detention law in place. The principle of preventive detention has been permanently embedded into the Indian legal system. And on that bleak note, the things to look forward to in 2023 are our fundamental rights to movement and residence and challenges to that, the expansion of Article 21 to include environment, livelihood, and my favorite, the right to sleep. We will also look at part 2 of the Constitution, which is citizenship and how that was shaped by partition. And lastly, how the coronavirus epidemic impacted our constitutional framework, amongst other things. Exciting episodes ahead, so don't forget to tune in next year. And may you have a nourishing and restful new year. Bye. Oh, just a second. If you have questions or comments, please send them in via email, thatsthelongestconstitution@gmail.com. You can also rate my podcast at Spotify and drop a review at Apple Podcasts. And can also reach out to me on Twitter, where I am at fundamentally or on Instagram, The Longest Constitution. Until next time, this is me, Priya Mirza, signing out.